Big Brother, or rather Big Data, is watching you. Our personal online information is now an important asset in the global economy. The potential for its misuse has led the European Union to start rewriting the rules on data protection. Nick Pickles is a privacy campaigner.
We're living in a society where our data is currency, and people often think that they're the customers of companies like Google and Facebook, but in reality, we're not their customers, we are their products, and it's our data that's powering their advertising businesses. So we do hand over a staggering amount of data, and the importance of revising the law is that these companies have been operating under laws that were written before the internet existed.
Using our smartphone, the web, shopping online, all leave little bits of data which companies can use. With this explosion in so-called big data, the European Commission has decided to update its law from the 1990s to put consent from the individual at its heart.
At the crux of the proposal is to put the protection of personal data as a fundamental right at the center of the law. The effect that has is that the law becomes much stricter, and therefore the rights are stronger, the obligations are more difficult to comply with, and the limitations and restrictions placed by the law on organizations are much wide-ranging.
The draft rules also include greater harmonisation and being able to go after non-EU based companies. Business is lobbying hard for moderation. Advertisers think that asking for consent at all stages could damage the UK's lead in digital marketing.
The implication of assumed consent as opposed to specific given consent at every point in the transaction would be a major disenabler to online marketing.
Tim Lefroy believes the draft rules wrongly treat personal and aggregate data as the same.
On the one hand, you have people's personal data, which people should rightly be concerned. It should not be held and should not be used in a way which is too close to them. And on the other hand, the type of data which is generally used for marketing and advertising purposes is aggregated data, and it tracks their behavior, their location, their intentions, but it doesn't actually track who they are.
Eduardo Ustaran, who represents some of the global technology companies affected, warns that business could be too restricted in its legitimate right to use some data, especially for free online services.
What I think about these proposals is at the moment they're not getting the balance right. What I see is that there is an emphasis on the protection of the individual, which I think is obviously the right thing to do. But at the same time, the rules are coming across as extremely restrictive in the way that organizations and public authorities can collect and use and exploit information about individuals.
But to campaigners, business will just have to adjust to the rules and the possibility of more competition through improved data portability.
Businesses do face challenges where they've grown up in the past decade of a thirst for personal information, and that's driven the digital economy. But if they have a problem because their business models don't work with enhanced citizens' rights, then that's a challenge to innovate their business models, not to undermine citizens' rights more.
Business and privacy campaigners will be fighting hard in the EU debates over data protection in what will be a long, protracted process before the law becomes reality more than a year away. Josh Delamere, Financial Times, London.